In this video, I'm going to explain construction disputes in Florida and what courts really care about when these cases land on my desk. By the end of this video, you'll learn the exact factors that win or lose construction lawsuits in Florida courts. And you'll know what documentation matters most. You'll understand how judges evaluate these cases. You'll also know what mistakes cost contractors and property owners thousands of dollars. I'm Santiago, Cueto board certified international business law expert and best-selling author based right here in Miami, Florida. I've represented both contractors and property owners in construction disputes throughout the state. And what I'm about to share today comes from real courtroom experience. And here's something most people didn't realize. Courts don't care about who yelled louder at the job site. They don't care whose feelings got hurt. What they care about is something entirely different. And if you don't understand this before you end up in litigation, you've already lost half the battle. The first thing you need to understand is this. Florida courts worship the written contract. I'm not exaggerating. If you signed a construction contract, that document becomes the Bible of your case. Judges read it, they interpret it, and they enforce it. Let me tell you what happens when there's no written contract. I once had a client who did a $100,000 renovation based on a handshake and text messages. The property owner refused to pay the final $30,000. My client thought he had a slam dunk case. He did the work, he had photos, and he also had witnesses. But here's what the court cared about. What were the actual terms? What was the scope of work? What were the payment milestones? Without a written contract, we had to prove everything from scratch. It turned a simple payment dispute into an absolute nightmare. Florida courts will enforce oral contracts, but you carried the burden of proving every single term. Every detail becomes a battle. The other side will claim different terms, different prices, different scope. You'll spend more on legal fees fighting about what was agreed than the actual contract was worth. So here's the reality. If you're a contractor, never start work without a written contract. If you're a property owner, never let work begin without signing something. Courts care about documentation, not stories. The second thing courts care about is change orders. This is where most construction disputes actually start. The project begins, things change, the owner wants something different. The contractor discovers unexpected conditions. Work gets added, and everyone thinks they'll figure out the money later. Big mistake. Florida courts will not grant you extra payment for additional work unless you can prove three things. First, that the work was outside the original scope. Second, the owner approved the change. And third, you both agreed on the price. Here's a real-world example. A contractor was building a custom home. Halfway through, the owner decided she wanted different countertops. The contractor installed them, and at the end of the project, he added $15,000 to the bill for the upgrade. The owner refused to pay. The contractor had no written change order. He claimed they verbally agreed. She claimed he never told her that the new countertops would cost extra. She thought they were included. Guess what the court did? They sided with the property owner. Why? Because the contractor couldn't prove the agreement. No written change order, no email confirmation, nothing. Now, if you're finding this valuable, do me a favor and hit that like button right now and subscribe to this channel because I share insider legal knowledge like this every single week. You won't find this information anywhere else. All right, let's keep going. The third thing courts absolutely care about is photo documentation. I cannot stress this enough. Take photos of everything before the project starts, during every phase, when problems arise, after you fix those problems, when the project completes. Judges are not construction experts. They don't visit job sites. They don't understand building codes like contractors do. They need to see what happened, and photos tell the story. I had a case where a contractor was accused of damaging underground plumbing during a renovation. The property owner claimed $10,000 in repairs. The contractor said the pipes were already damaged. It was a classic he said, she said situation. But this contractor was smart. He took photos before he started work. He documented the condition of everything. He had time-stamped images showing existing damage. The case got dismissed before we even got to trial. On the flip side, I've seen contractors lose cases they should have won. Why? No documentation. They did beautiful work, they fixed major problems, but when the owner claimed defects, they had no proof of what they actually did. Now here's what courts want to see. Before photos, progress photos, photos of any pre-existing conditions, photos of completed work, and if there's a dispute about quality, photos become your best witness. And the fourth thing courts care about is timing, especially when it comes to mechanic liens. A mechanic's lien is your legal right to get paid for construction work, but Florida has strict deadlines. If you're a contractor and you don't get paid, you have to file a claim of lien within 90 days of your last day of work. Not 91 days, not 3 months and a week, 90 days exactly. Miss that deadline and your lien rights are gone forever. The courts won't care that you were busy. They won't care that you didn't know. They won't care about your excuses. The statute is absolute. Now, I've seen contractors lose six-figure claims because they filed their lien on day 92. The property owner's attorney filed a motion to dismiss, and the judge had no choice. The lien was invalid. And here's another timing issue courts care about: notice requirements. If you're a subcontractor or supplier, you have to serve a notice to owner within 45 days of first providing labor or materials. The notice protects your lien rights, and Florida courts will not bend these rules. They exist for a reason. Property owners have the right to know who's working on their property. They have the right to know who might file liens. If you don't follow the notice requirement, you lose your rights. Now, the fifth thing that courts care about is who has the burden of proof. This matters more than you think. In construction disputes, the person making the claim carries the burden. If you're a contractor claiming you're owed money, you must prove that you did the work. You must prove the value. You must prove you weren't paid. The property owner doesn't have to prove anything. They can just sit there and deny everything. Now, if you're a property owner claiming defective work, you carry the burden. You must prove the work was defective. You must prove it violated the contract or building codes. You must prove the cost to repair. The contractor can simply deny your claims. This is why documentation matters so much. The burden of proof means nothing without evidence. You need contracts, you need invoices, you need photos, you need expert witnesses, and you need paper trails. Courts don't guess. They don't assume. They require proof, real evidence that meets legal standards. The next thing courts care about is damages. You can't just throw out numbers and hope the judge believes you. You need to prove every dollar that you're claiming. If you're a contractor claiming lost profits, you need documentation. What were your costs? What was the contract price? What did you actually spend? Did you have receipts, invoices, bank statements? If you're a property owner claiming repair costs, you need estimates, multiple estimates from licensed contractors, expert reports, proof of what repairs actually cost in the real world. Florida courts won't award damages based on speculation. They won't accept made-up numbers. They require objective evidence. And here's something else. Courts care about whether you mitigated your damages. That means you took steps to minimize your losses. If you're a contractor and the owner breached, did you try to find other work? If you're an owner and the contractor walked off, did you try to get someone else to finish the job? If you just sat there and let damages just pile up, courts might reduce your reward. They expect reasonable people to act reasonably. So let's bring this all together. Florida courts care about written contracts. They care about change orders. They care about documentation and photos. They care about timing and deadlines. They care about burdens of proof. And they care about proven damages. Now, if you want to win a construction dispute in Florida, you'll need all of these elements working in your favor. You can't fake it. You can't wing it. You need to build your case the same way you build a house, with a solid foundation. Now, if you found this helpful, smash that like button and subscribe to this channel for more legal insights that can save you thousands and hundreds of thousands of dollars. And share this video with anyone in the construction industry. This information is gold. I'm Santiago Cueto, your Florida business attorney. Be sure to watch more of my videos right here.